So talk about your David versus Goliath before the U.S. Supreme Court. One of the most powerful unions in the country may have met its match in a stay-at-home mom who cares for her severely disabled son. Garrett Tenney has that story live in Chicago. Is it right that this case could have an impact on unions across the country, Garrett?
Yeah, Bill, labor law experts say that if the court rules in her favor, that it would be a major blow to unions nationwide, essentially crippling their ability to collect dues.
Good yogurt.
25-year-old Josh Harris was born with a rare genetic disorder called Rubinstein-Tybee syndrome, which requires constant care and supervision.
And we feed him. I help him wash his face, shave him, brush his teeth.
Pam Harris is not only Josh's full-time caretaker, she's also his mom.
I love you so much. I know with the beat of his heart, he is a part of me. I can care for Josh better than anybody.
But in 2009, an Illinois law required all home health care workers to pay fees to a union representing them, whether they wanted to be a part of the union or not. And that includes Pam, even though she cares for her own son in her own home. She says the union fees would take away from the small amount the family receives from Josh's Social Security to help cover his medical costs.
I don't want to be forced to join a union, and I'll be darned if I'm going to let the union take Josh's supports.
Now the U.S. Supreme Court will decide the case.
At the heart of Harris v. Quinn is a mom who's trying to do what's right for her son and protect his supports and services.
The unions involved see it a bit differently, though. In a statement, they say Pam's efforts represent, quote, not only a radical assault on a long-standing Supreme Court precedent, but also a cavalier indifference to the welfare of seniors and people with disabilities. And, Bill, the U.S. Supreme Court is set to announce its ruling on this case in June.
All right, we'll see you then. Thank you. Garrett Tenney in Chicago on that.